To this now, the US has dismissed South Africa's case against Israel at the International Court of Justice over the war in Gaza. South Africa argues that Israel is committing genocide in Gaza in the case filed at the ICJ last week. White House National Security Council spokesperson John Kirby says the US considers the case meritless, counterproductive and completely without any basis, in fact, whatsoever. Israel has rejected South Africa's genocide allegations, terming it baseless and blood libel. Meanwhile, the International Court of Justice has announced in a statement that it will hold public hearings on the request for provisional measures submitted by South Africa. International law professor at University of Johannesburg, Hennie Strydom, joins us now via video link to unpack the case brought to South Africa against Israel at the court, the ICJ. Prof, thank you so much for your time. Well, since our last conversation, there have been several developments since South Africa launched its application. Of course, both Israel and the US are having reacted to that statement. You just heard now in my introduction about John Kirby just labeling this particular case as meritless, counterproductive and completely without any basis. When you consider South Africa's 84-page application, is this case without merit?
Certainly not. I think it's a well sort of crafted document. It's setting out the history, the facts, and why South Africa is bringing this application to the ICJ. And obviously, there is now, as South Africa has also stated, a dispute between itself and Israel concerning the interpretation and application of the Genocide Convention. And that is the whole premise of South Africa's case. Yeah, and that makes it very important that Israel responds to that, because it certainly has a case to answer, especially as regards the interim measures, which I think is an urgent matter, and normally the court will also deal with it in that way. And I think that is the correct sort of approach by the court, to say there will be oral hearings on that issue soon.
When you consider the countries, that are involved in this particular case, and the fact that, there are, members of, the UN and so forth, just talk to us again about how you bring about such, charges, or application, arguing in terms of was there genocide or was there not? What is key in terms of bringing that up? What are some of the statements you need to draw to make your case?
Well, first of all, we must understand that there's a clear provision in the Genocide Convention stating that when there is a dispute between parties to that convention on the interpretation application of the Genocide Convention, any one of those parties must bring that dispute to the ICJ. So that is the starting point. And South Africa has provided the facts on which it sort of bring the claims for the court to decide, and the allegations, providing facts and also providing statements by UN officials and other world leaders, making the point that the action that Israel has taken has reached the point where it can be said that there is genocidal intent. So it is for Israel now to come and counter those allegations and provide evidence to the contrary. And that is why it is very important, I think, for Israel and for the whole case, that part, or that the submissions by Israel will also be taken into account. And that is what the court will do. And I'm actually glad that Israel is on record saying that it will sort of counter South Africa's allegations.
Now, in its application, I want us to look at a little bit of what it contains. South Africa highlighted a number of comments made by senior Israeli politicians, including the Prime Minister himself, Benjamin Netanyahu, that there was somewhat in violation of acceptable practices, in situations of war, and violating the 1948 Genocide Convention that you mentioned just now. Can South Africa then draw some kind of legal connection between these statements, just given that Israel is a signatory to that convention and is therefore, subject to the jurisdiction of the ICJ, which is a UN organ?
Yeah, the the importance of the statements that South Africa has referred to has to do with the element of intent. So in order to prove genocide, you have to prove direct intent, that there was a genocidal intent to commit the offences or the crimes that will amount to genocide under the Genocide Convention. And that is why that element South Africa has decided to insert in its claims, apart from the factual situation concerning the targeting of civilian objects, the number of civilians killed, targeting of hospitals, of infrastructure, etc. So taken all together, that is what the court will use in order to decide whether we have reached the threshold in this conflict where the court can say, well, it has come to the point of genocide. And the moment that happens, then there is a duty on Israel to prevent it, because that is one of the duties that member states under the Genocide Convention have. And that is to take certain measures to prevent it from happening. And that is what South Africa is asking for. But that deals with the merits of the case. So when it gets to that point, and the court finds in favor of South Africa, then, of course, it will also then say, under the Genocide Convention, Israel now has a duty to prevent it from happening.
Should the ICJ, give the Israeli government a cease and desist order, all acts of genocide, of the Palestinians, what will be the implications then, not only to Israel, but to I think you touched a little bit on that, but also to the Biden administration in terms of the Genocide Convention, just given that the US in particular has been aiding Israel with some military arms amid the war?
That is the other important aspect. If South Africa is successful, it would mean that all member states under the Genocide Convention will now have to take strong action to prevent genocide from happening further. And I think that is a secondary offspin should South Africa be successful in its application. And of course, that includes the United States of America.
To what extent, Prof, will the support of other countries and civil society groups, assisting in South Africa's case, bear merit to the case?
That's very important. There is, under the statute of the ICJ, the opportunity for other states to intervene in the proceedings and to submit arguments. And I have already heard that some states have decided to do so. I can just use the example of Ukraine versus Russia, where 21 states have intervened in support of Ukraine's also request for interim measures, pending the outcome of the case for interim measures pending the outcome on the merits. So, of course, that is important that states join in the proceedings in that way, which will then give the court a sort of much more broader spectrum of views and circumstances and probably also facts, which it then can take into account to come to a conclusion.
Prof, just as we conclude, of course, all eyes will be on, in The Hague, essentially, in terms of, next week's processes. I mean, yesterday, the court, the International Court, in fact, issued out a statement just saying that it will hold public hearings on the request, of course, of the provisional measures submitted by South Africa. Where does that all fit in terms of what we could be expecting in terms of those public hearings?
Well, that's the first step because of the urgency of the matter. And I have to add here that the threshold for in order to be successful in your application for interim measures is a lower sort of threshold. All that South Africa and the other intervening states have to prove is that there's a plausibility that if the interim measures are not granted, then the civilian population may suffer irreparable harm and further life-threatening circumstances. So in terms of the facts that I have seen in South Africa's applications and I'm sure that some other states will also bring evidence to that effect. There is a fairly strong case made out by South Africa on the interim measures part. And I think there's great potential for South Africa to be successful on that point.
Prof, thank you so much for your time this afternoon. Really do appreciate it. International law professor at the University of Johannesburg, Professor Hennie Strydom.